Good morning and welcome to today's Ask a Pro webinar. Today's topic is protecting your secured auto loan in bankruptcy. My name is Milos Gvozdenovic and I'm joined by Scott Fink, who is the Bankruptcy Group Chair and a shareholder here at Weltman. We both work out of the firm's Cleveland office. A little bit about myself. I am an attorney. I'm licensed in Ohio. I've been an attorney now. I'm looking at my diploma here. This November is going to be 20 years. I've been with Weltman for 8, and I have been practicing law for the full 20 years that I've been here. I'm going to pass it over to learn a little bit more about Scott.
Thank you, Milos. Good morning, everyone. First of all, to clear up any confusion, you'll see my name is Garry Masterson on the screen. I am not Garry Masterson. I'm filling in for him today. He had a personal matter, so you get me. Hopefully that's a good thing. A little bit about me. I've been with the firm for 20 years now, and I've been running the bankruptcy group as the chair of the practice group for, I think it's about 8-9 years now. Been focusing my practice on bankruptcy for probably 25 of the years I've been practicing. Yeah, we're just very excited to share a little bit with you guys today and answer what questions you might have. I do want to add one thing. I'm going to encourage everybody to, because we're going to do the best we can to get to your questions. But we're going to be getting probably a lot from all over the place, and that's a good thing. I imagine that you are all seeing what we are seeing, which is an increase in bankruptcy filings, an increase in bankruptcy issues on your end within your shops. So I'm imagining you will have a lot of issues or questions you want to address. Some of you may not feel comfortable asking them today. I just want to encourage each of you to reach out to us after this webinar. You will see our contact information at the end. You can reach out directly to myself or to Milos or to Garry with questions, anything you've got by email or by phone, and we will work with you one-on-one. So with that, back to you, Milos.
All right, great. Thank you, Scott. All right, before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. Also, there will be a short survey on your screen at the conclusion of the event. Please take the survey and share your feedback, and we greatly appreciate hearing your opinions on our webinars. Without further ado, let's get into the first question. Okay, so the first topic here is we're going to talk about reaffirmation agreements. So I'm going to start by answering this general question and give us some general overview, give you some of my thoughts on it and some issues that I've kind of been seeing and some pitfalls that a lot of our clients are falling into on these. And then as Scott said, we're going to go to the questions. We've had some of you send questions ahead of time. We've actually went through those questions, and then feel free to send questions live. I will add one thing to what Scott said, is we did get some questions that are slightly off topic. So we are going to prioritize questions that are on topic first. If we have time at the end of the webinar, we'll circle back on some of the more general bankruptcy questions. But also, as Scott indicated, you are always welcome to reach out to us directly if you have any bankruptcy specific questions. So, all right, what are the most important aspects and pitfalls in the vehicle reaffirmation process for creditors? All right, first thing I want to say is the reaffirmation process isn't limited to vehicles. We are focusing on vehicles in this webinar, but a majority of the things that I'll go over in terms of a reaffirmation for vehicles will apply to real estate as well as unsecured debt. But in terms of pitfalls for vehicle reaffirmation process, let's start with what a reaffirmation agreement is, because I know some of you that sent in your questions were asking, someone's comment was bankruptcy for dummies. So let's start with the reaffirmation for dummies first. So what a reaffirmation agreement is, when someone has a loan with a lender and they file for bankruptcy, particularly if it's a secured loan, let's just focus on autos here. They have 3 options on what they can do. They can surrender the collateral, they can redeem the collateral, and they can reaffirm the collateral. So what is a reaffirmation agreement? Essentially, they're signing a document that is prepared and circulated with all the parties, and that document is then filed with the court. What the document does is outlines the loan, it outlines the collateral, it outlines what the monthly payments are, and when that document is filed with the court, that loan is treated as if it was never in the bankruptcy in the first place. So, if you ever have a customer or a member or client, however you guys refer to your borrowers, comes in and normally says, I filed for bankruptcy, but I'm going to leave you guys out of it. I think that's what they essentially meant, because the way the bankruptcy works is they can't leave anybody out. When somebody files for bankruptcy, whether they intend on paying or keeping a debt, they have to list everybody that they owe money to on the bankruptcy schedules. So they can't essentially leave them out. But what they can do is reaffirm the debt. So if they have a car loan in there and they say, we want to reaffirm the car loan, or we want to leave the loan out of the bankruptcy, they have to reaffirm that loan. When that loan is reaffirmed, then everything goes back to normal as it was prior to the bankruptcy. You can contact the debtor, you can send billing statements, you can do collection phone calls. If they fall behind, you have a right to repossess the vehicle. You also have a right to sue on the note. So the easiest way to look at it, when somebody reaffirms an auto loan, that reaffirmation document essentially treats that loan as if it was never in the bankruptcy. So that's the easiest way to explain it. I think there's a lot of confusion sometimes when people get reaffirmation agreements signed by debtors. They ask, what now? What happens now? Just treat it like as if bankruptcy is never filed. That's the easiest way to approach it, because that's essentially what it is. That loan is not subject to the bankruptcy discharge because it was reaffirmed. So all treatment of that loan goes back to the way it was treated if a bankruptcy was never filed in the first place. Okay.
So Milos, I'm going to stop you there real quick, and I'm going to head off a few questions which I know we're going to get, and we're going to answer them right now. One of those is one of the most popular questions: is it a voluntary process, or is it something that you can force? Can you demand that your borrower reaffirm on a debt? So that's one that I know we get all the time, and the simple answer to all of our attendees today is it is a voluntary process. A creditor cannot force a borrower to reaffirm a debt. It is a completely voluntary act that a debtor can choose to reaffirm or not reaffirm on any debt where an agreement is presented to them. And conversely, a creditor cannot be compelled to enter into a reaffirmation agreement with the borrower.
Yes, and just to build on that, actually, Scott brought up a very good point. That'll lead us into some of our questions. One of the questions, I know I saw it, and I'm kind of sifting through my pages because I'm getting a little ahead of myself here. What actions can be taken if the client refuses to sign the reaffirmation agreement and does not pay the loan? I think there's two questions there, right? Because a member or a client can reaffirm a loan but not pay, but they can also not reaffirm a loan and pay. So let's break it down in two separate points. What if the client refused to sign the reaffirmation agreement? And Scott may have a differing opinion than me. I think you're well within your rights to repossess a vehicle if a member does not reaffirm the car loan. Now,
once the discharge goes on.
Correct. Not while the automatic stay is there, but once the case is discharged and everything's completed, if they didn't reaffirm by the time the case discharges, I think you're well within your rights to repossess the car. So, debtor's attorney may make their argument and say, listen, they're current, they're making the payments. Our counter argument would be is, it doesn't fall, retain and pay is not an option under the code section, number one. Number two, what's your assurances or protections if the debtor doesn't reaffirm? Yes, they're paying now, but then the thought is if they decide they don't want to pay a year from now and they just turn in the car, they can do it with no repercussions. In the meantime, your car is depreciating in value. You have to be concerned about insurance.
And you know where the vehicle is now, by the way. This is the point where you have them. You know where your member is. You have an attorney on the other side. You can make those arrangements. If it's a year down the line, I don't know where that customer is going to be. So where's my vehicle going to be? So yeah, there's a lot of reasons to say like, well, maybe strike while the iron's hot. Now, the alternative view on that, which I'm sure a lot of people on this call would take the position, and I normally would counsel my clients to say, look, if you have a borrower who's willing to pay you and is paying you, and the loan is current, I'm not really going to say to you, go take the car. I think times have changed, and it's actually swinging back the other way, where we had this incredible blip where used vehicles were appreciating in value or were holding their values to a point where everybody was just saying, well, I'll take it to auction. Not only will I sell it for everything I'm owed, but I'm going to have a surplus afterwards. I'm going to have to return to the borrower. That's probably a very unique point in history that, while it may still be happening to some extent, it's happening less and less. And usually, historically, traditionally, you take a car to auction, you're going to get less than what you were owed. You're going to have a deficiency. So you're weighing these things and saying, is it better to just allow the borrower to continue to pay? If they don't pay down the line, you can always repossess it then, but take the money, not the car.
Yeah, that's going to
you can
be,
go either way with it.
that's going to be strictly a business decision, right? Should we repossess it, not repossess it? Will we get some pushback? Maybe. There are some aggressive attorneys out there that may fight you on it if the member is current, but our position is if they didn't reaffirm, you're absorbing a lot of risk, and I think you're well within your rights. But Scott does make a valid point. I think most of our clients, particularly in today's market, would probably rather have the money than the car. There's costs with repossession, there's costs with auction that takes money from your bottom line. The debtor didn't reaffirm, you're not going to recoup that money. So if the money's flowing in, they're paying regularly, they've been a good customer, you may make that decision. And I think more often than not, our clients do, where you let them retain and pay. But you're not obligated to do so. So that kind of flows in. There's another question, how to handle secured autos that do not reaffirm and want to pay and maintain. Western PA district isn't fond of reaffs. That kind of falls back. It's going to be a business decision. Do you just repossess it, cut your losses, and be done with it, or you just take the money while it's coming in and take your chances? So I guess it'll depend on your customer too, right? If they've been historically a good customer, I would imagine you're more apt to allow them to retain and pay, but that's going to be ultimately your decision. So here's the second part of the question. What if they don't pay the loan? That doesn't change regardless of whether they reaffirm or don't reaffirm. So if a member, client, customer, whatever you call debtor, as we call them, does not want to reaffirm and they don't pay, you can repossess the car and sell it, as long as the automatic stay is not in place. The bankruptcy has to be past that point, either discharged or stay had to have been granted in some capacity. But when you repossess the car, the only difference is if they didn't reaffirm is you can repossess, sell the car. You can't pursue them for any deficiency balance. So if the car does not sell for enough to cover what's owed, that's all you're getting is the value of the car after sale.
I think this is a good opportunity to sort of, with an eye towards bankruptcy for dummies and bankruptcy 101, I'll be the dummy here. The question that would be posed is sort of like, how, when a discharge goes on in a Chapter 7, what is that really doing to a secured loan? And to answer that, I think we need to take a step back. And I always try to explain this to my clients and people when I'm speaking on the topic. A secured loan, let's use vehicles as the example for now, because that's what we're talking about today. When your customer enters into an agreement with you and you loan them money and you take a lien on their car, it's really two separate things. That they're two pieces of paper, even though it's combined into one. A note and security agreement is typically how they're titled. That's what they're called. It's really two very different things that are being signed or legal documents combined into one. The note is the borrower's promise to repay the debt. When a discharge goes on in a Chapter 7, if the borrower does not reaffirm, then what is being discharged is that note, the borrower's promise to repay. That is discharged. They are no longer liable to repay the money. But then you've got the other side. There's two pieces to this. The security agreement. That is the borrower, when they are agreeing to repay the money, they're also saying, and in exchange for you lending me the money, I'm granting you a security interest in the vehicle that I'm buying. So then that's great. And then you, as a secured lender, you then need to record your lien, perfect your lien by putting it on the title. The lien, the security interest, does not get discharged in a Chapter 7. The promise to repay does, but the security interest, the lien, does not. Thus, the ability, when we're talking here about if a discharge goes on and there's no reaffirmation, you can go repossess the car because you still have the right to your vehicle. You still have the security interest. What you don't have is the borrower's promise to repay anymore, and therefore you can't chase them personally for money that's owed or for deficiency after sale. So just want to set the table with that.
All right, very good. So we're going to switch topics here on reaffirmation agreement with another question that kind of opens up another door. It was a very good question. Does the debtor, does the auto have to be current prior to reaffirming? No, but generally we never prepare a reaffirmation agreement unless that arrearage is addressed. Our standard practice at the request of our clients is when we prepare the reaffirmation agreement, one of the terms is that that loan has to be current by the next payment due. You know, if it's a singular payment or a couple payments, generally not an issue. What happens if the member wants to reaffirm and the loan is delinquent 5, 6, 7 payments? We're talking thousands of dollars. Well, you do have some flexibility as the lender on these reaffirmation agreements. You can require them to bring it current. If it's been a difficult debtor and they've been perpetually behind and they've just been a poor customer and you just don't want to deal with it anymore, it's, you know, bring the money current, reaffirm, or we're going to repossess, or, you know, we'll get relief and repossess the car. If it's been a good customer or you want to maintain that relationship, or you know, you'd prefer to get the money than the car, you can use the reaffirmation agreement to modify the terms of the loan. So how does that work? The most standard example is that members behind on the loan going into the bankruptcy. They want to keep the car, but they can't come up with $5,000. Are you willing to put that $5,000 at the end of the loan extended by the number of payments to cover that, you know, that arrearage? Once again, you're not obligated to do anything like that. It's solely a business decision. But once again, you're getting somebody to obligate themselves personally on a loan. If the car is not worth what's owed on it, or you trust the member enough to pay it, or you just want them to have more skin in the game, so to speak, then sometimes it may be best to entice them and put the arrearages at the end of the loan. You can also do an adjustment in interest. If the debtor has a high interest rate, they're paying 10, 15%. They say, hey, can you bring it down something to 8, 7, 6%, and I'll sign the reaffirmation agreement. You're not obligated to do it, but you can if you want. So, you know, you have
a lot of flexibility in the process, is what we're trying to tell you. You can't be forced to do it, but it is a tool. It's yet another tool that you can use. You know, if the only thing standing between your borrower reaffirming on a very high balance loan and not reaffirming on it is dropping the interest rate by a point, I mean, yeah, you'd have to rework potentially what the payment amount's going to be as well. But again, that's a business decision for you.
Yeah.
Because if they won't reaffirm, now you still have your lien and they may still pay, but you don't have that personal interest in the loan where the borrower can be forced to repay down the line.
Yep.
And a lot about
in the same line with that is, and this is one of the things, this is one of the issues that I keep seeing repetitively that's kind of prompted me to choose this as the subject for today's presentation, is if you modify the terms of the loan prior to bankruptcy and then you send us a reaffirmation agreement to outline the terms, you got to make sure that the terms match the way you understand that agreement. The most common thing that I'm seeing is we'll get a referral from a client and it'll say the member owes, you know, $5,000 and they have X number of payments at X dollars left. Well, when I project out the math isn't adding up and the total amount of payments doesn't even add up to the payoff. So at some point in time, you and the debtor have modified the terms of the loan, but have not provided that information. That has to be outlined and accounted for. We don't just sign this document and it gets filed with the court and it gets stamped and everybody, you know, approves the loan as it's understood to be. The terms that are in the reaffirmation agreement are going to be controlling. So if you've modified the terms of the reaffirmation agreement, you're going to be obligated to those terms from the bankruptcy going forward. If you put in the normal contractual terms, then it's just going to be the contractual terms, right? But if there's been some changes, you have to disclose those changes, and those changes will be controlling. So please, when you send a referral, if there's been any skip payments, loan modification, interest reduction, make sure to send that information over and make sure your math adds up, because we're not going to be able to prepare and file the document without that. And if the numbers don't add up, that's a quick way to get called in before the judge to provide an explanation in terms of why the numbers don't add up. So that is you know, that is something to look out for when you send over the reaffirmation agreements. Another question that came up here, and this kind of stands on its own, is can a reaffirmation agreement be submitted after the discharge has been granted by the judge? Actually, Scott and I just had this conversation privately on a file recently. So the short answer is no. There are some judges, there are a few that our general rule of thumb, I think Scott and I are in agreement that if we get the reaffirmation agreement filed before the discharge is ordered, that you're generally covered. I'm comfortable enough telling a client, we filed the reaff, the case hasn't discharged yet, we're good, right? It gets a little tricky because the court does set a discharge deadline. It's, I think, 90 days from the date of filing. And the discharge doesn't normally get issued immediately. Like the discharge deadline comes and goes, the judge isn't sitting there waiting to stamp that order. It may be a 2 or 3 day lag, sometimes a week or two lag before the actual discharge order is issued. So, in those circumstances where we slip it in after the deadline, but before the actual order gets issued, most judges don't care. But there are a few select judges that do require you to seek leave or permission from the court before they're going to approve it. Now, after the discharge is entered and you file it, I probably would say that that's not going to work. I know Scott and I had a brief discussion. Also, what if it was signed before?
Right, because there's a requirement. A debt is supposed to be reaffirmed before the deadline expires, or before the discharge is issued, I should say, before the discharge goes on.
Yes, I wouldn't rely, and I think we're in agreement on this. I would not rely on a reaffirmation agreement if it was filed after the discharge, even if it was signed before.
No.
I do think as a matter of caution, if that happens, we could seek leave from the court to approve it. The debtors council, we've seen this before, they're usually not keen on doing it. They'll vacate the discharge temporarily for the purposes of the reaffirmation agreement. I don't think any debtor wants to concede their discharge once it's been granted, even though it's maybe more.
The rule of thumb is pretty simple. You need to get these signed and executed before the deadline expires, before the discharge deadline, and then get it filed before the discharge goes on. That's the rule of thumb. And if it is other than that, reach out to counsel and see what your options are.
Yeah,
there may be some backdoor ways, but it's going to be a bit of an uphill battle.
Yeah, don't assume. Don't assume anything.
Right.
I think the conservative approach is the best approach because the risk on the back end of you being accused of attempting to collect on a discharge debt is high. One last item I want to touch on with reaffirmation agreements before I pass it on to Scott in the lien discussion is rescissions of a reaffirmation agreement. So once, let's say the reaffirmation agreement is circulated, we agree to the terms, it's been filed, the judge has no issue with it. The debtor still has a window of time to back out of a reaffirmation agreement. What's their window of time? It's the later of two dates. It's the discharge date, so when the court issues the discharge order, or 60 days from the date the reaffirmation agreement is filed with the court. It's whichever is later. If we file a reaffirmation agreement today and the case discharges tomorrow, it does not mean the debtor cannot back out. They still have 60 days. On the same note, if we file the reaffirmation agreement early in the case and 60 days have come and gone, until that discharge is order is issued, they can still back out. How do they do that? The rule only states that it has to be a written rescission.
Yep.
From a practical standpoint, most attorneys that are pretty sharp will probably file a notice of rescission with the court. It's in writing, it's transparent, it's on the docket, nobody can question it, right? That's typically how we see it. Now, if a member sends you an email or sends you a letter, I would probably say you're gonna have to rescind
honor it. That's a rescission.
Yes, I agree. I think you're gonna be bound by that. Now, where it gets tricky, and Scott may have a different opinion than I can, is verbal rescission. I don't know. I'm torn. I really think if someone tells you verbally, my rule of thumb is, can you put it in writing, right? But if they don't put it in writing and they put it in writing a day late because you told them they need to be in writing, that's a gray area. I would tell my clients.
Code says what it says.
Yeah, I'm more conservative.
You can be a stickler to it, but it's a business decision.
Yeah, I'd be nervous, but Scott may be a little more adventurous than me on this one.
Well, I just think the code is what it is. In writing, you got 60 days.
Yeah,
that's it.
So
before we move on, I have another. This is It's not a question that we got, but it's a question I would anticipate, and I know there are people out there thinking this. There's all this discussion about reaffirmations, and really what we've been focusing on is the benefits to our clients who are on the line right now. And the obvious counter to that is, why in the world would any debtor agree, or their attorney agree, to reaffirm a debt? Because all they're doing is binding themselves to a debt that they could get out of. And gee, if I'm listening to Scott and Milos here, they're sure making it sound like they would advise their lender clients to continue accepting payments from somebody even if they don't reaffirm. So why would a debtor reaffirm? What are the positive aspects? And really what I'm saying is, what is our selling point on behalf of all of our clients on the line here? How do we sell these things to the debtor and the debtor's attorney?
Well, actually, that's a very good question, because just reminding me that's the second hot button issue that has been coming up is, what's the benefit to the debtor? And to be honest with you, I feel that my personal thought is there are obligations on the lender on that end as well. If the biggest selling point for an individual to reaffirm a debt is to rebuild their credit, right?
Yep.
It should show up on their account as an active account that they're paying regularly, that wasn't part of the bankruptcy. So if we've had situations in the past where a member or a debtor reaffirms a loan, and then the borrower does not update the credit report. That's one of the biggest selling points for somebody to reaffirm, is to show a positive account on their credit report. If you're not reporting it as active after somebody reaffirms, I really think that you're potentially putting your neck on the line by not complying with the bankruptcy code. But it does work both ways. If a debtor does not reaffirm a loan, and then you're still reporting as a delinquent account on the credit report, that may be a violation of the bankruptcy discharge. I almost think it is. So you have to be very, very attentive and make sure, if a loan has been reaffirmed, report it appropriately. If it has not been reaffirmed, reported appropriately, because there's serious repercussions both ways. People are much more savvy with reviewing their credit and their credit scores and rebuilding their credit. And there's a lot of information online. So you guys have to be on top of that. So that is a very, very, very good point.
Yeah, I mean, it's something where I really do sell this, and I know all of our attorneys do. A lot of debtors go into bankruptcy and they just don't understand that when they tell their attorney, or they tell me as your attorneys, well, it's fine, I'm going to pay on this. I'm going to pay for the car. I'm going to pay all the way to the end. I've never missed a payment. And you have to explain to them, that's great. But do you understand that if you make every payment like clockwork for the next 40 months until the loan matures, that's awesome. You're going to get your title and you'll have your car free and clear. But what you're not going to get for the next 40 months is any credit reporting that rebuilds your credit at all. Yep. The only thing that a lender can report, and needs to report, upon a Chapter 7 discharge, if it wasn't reaffirmed, is Chapter 7 discharged. That's it. That's it. You should not report anything more than that, and that does not positively or negatively impact their credit going forward. I mean, they'll take the hit from the filing of the bankruptcy, but it doesn't build their credit back up. So that's one big aspect. But the other big aspect of why someone should reaffirm on a debt is, if hypothetically they don't reaffirm on a car loan, and like, it's what happens in it's life, okay? Stuff happens, death of a loved one, you lose a job, you go through a tough spot, you get sick. You want to be able to work with your lender. You want to be able to pick up the phone and call your lender and say, hey, this is going on. I'm going to be a little late on my payment this month, or is there anything we can do? Can I make a double payment the following month? And in my experience with all of my clients, lenders want to do the right thing with their customers. You're not out to like take their car. You'd rather get the money and you'd rather work with them. It's a long relationship, and you hope to have future relationships with them, making future loans. The problem is, once the discharge goes on, if they didn't reaffirm, you are barred from speaking to them. You can't take their calls. All you can do is say, I'm sorry, I show the debt is discharged. I can't speak with you. I can only speak with your attorney. And really, the only recourse you have upon the discharge of a car loan is to go and repossess the car. You can't rework the loan. You can't rewrite the loan because there is no more loan. There's no more personal obligation of the borrower. It's been discharged. So anything that you try to do to rework it and put money at the end of a loan, you can't. There is no actual obligation that they can agree to repay on.
Yeah,
So
and you're right.
There's a huge benefit.
And it becomes a slippery slope then too, because you may be thinking you're doing right to the member if they didn't reaffirm, you're trying to work something out, but it's a fine line between helping somebody out and that being viewed as attempting to coerce somebody or force somebody to pay a debt that was discharged in bankruptcy. Actually, we had a flurry of questions here, Scott. I don't want to cut into your time with the lien stuff, but I don't know if you wanted me to go over a couple of these real quick.
Yeah, go for it. Yeah, let's do it.
Okay. Let's see. If we want a repo on a voluntary repayment situation, no reaff, and it hasn't been discharged, do we have to petition the bankruptcy court to do so? Yes. Very important thing. Scott touched on it very important earlier on. And I don't want to glance over. I know we're focusing on one subject. That's why it's very difficult to focus on these without pulling in other things. But when somebody files a bankruptcy, always remember the most important thing and the easiest way to get in trouble, there's an automatic stay. You can't collect on debt, you can't call, you can't send billing statements, you can't repossess a car. That is in place until you get permission from the court to go after the collateral. So when we say, every time when we said you can repossess the car or you can take the car to auction, that is on the presumption that you have obtained relief from stay. So yes, before you take action against the collateral, you would have to make sure that the discharge in the case has been issued, or you've petitioned for the court and gotten an order for relief before doing so. So we're going to add that to everything we talked about earlier, that you need relief from stay in order to proceed against the collateral. So very, very, very good question. And I'm glad Scott brought that up earlier. All right, if someone has two loans, one auto loan secured and one signature loan unsecured, person files Chapter 7 bankruptcy. The vehicle is voluntarily surrendered to be sold. The car was sold at auction. The car sold for more than what was owed for the secured loan, including all fees and costs. Can the overage be applied to the signature unsecured debt as right to offset setup? I would say only if you have a valid cross-collateralization clause.
That's exactly right. Because otherwise that debt was discharged and you are trying to apply money to a discharged loan.
Yes.
Can't do it.
Yeah, make sure that if you have the proper language in your loan. What happens if you send the reaffirmation agreement to the debtor's attorney to forward to their client and they choose not to, but the debtor still wants to reaffirm the debt? What can be done in order to get that filed? That is a great question.
And it happens all the time.
Yep, and I'm glad you brought that up. The unfortunate reality of the world is there are bad attorneys out there. And what's even more unfortunate is we are bound by the law and you cannot deal with the debtor directly if he's represented by counsel. Reaffirmation agreement aside, Scott's been doing this longer than I have, and he can attest to this as well. I cannot tell you how many calls we get from debtors that call and say, I cannot get a hold of my attorney. I want to do this. What can I do? Unfortunately, it's very tempting, but don't do it. They're going to want to look to you for advice, or it's a trap. I'm not saying they're trying to trap you, but it could be a potential problem for you. And you got to tell them, you got to go through your attorney. We cannot give you legal advice. We can't help you. You are legally represented by an attorney. Your case is active. If you have an issue with the attorney, go to your local bar. You can report them. You can fire them. You can hire another attorney. I mean, most people are not going to do that because they don't want to waste the time and money. But unfortunately, they're stuck, and in turn, you're stuck. I'm gonna step in and offer a real world solution, though, which yes, it seems self-serving, but it's not, because there are many people on this call who they use different counsel, I'm sure, for their bankruptcy work. So it's not about give it to me. It's just if you run into that situation where your borrower's calling you and saying, I want to reaffirm, or my attorney won't return my calls and I want to reaffirm, but they won't allow me to. Reach out to us. Reach out to your attorney, whoever that may be. We will contact the borrower's attorney and have that conversation with them and explain, look, this individual wants to reaffirm. Can you take a second look at this one? There are ways to do it where we can even get them to allow their client, the borrower, to sign the reaffirmation, and the attorney won't. The attorney will not put his name on that document. Some of them ethically don't think that they should because they think it's a bad deal, and that's okay. If they don't want to sign it, there's ways to get them approved without their attorney even signing it, but it's got to go through their attorney. You can't
go around them and speak to the borrower directly.
Yeah, I think we tend to have a little more luck when we contact the attorneys. Once again, not a pitch for our services, but we have some established relationships, but there are always the few that, we'll email, we'll call, and they do nothing. That is the unfortunate circumstances. All right, we had one more question on reaffirmation agreements from what I could see so far that was submitted. Should be a simple one, then we'll jump into the lien issues. What if a member wants to reaffirm on an unsecured loan? Is the process similar to a secured loan? Yes, identical. Completely voluntary. Obviously, a lot of times the debtors don't have as much of a vested interest because there's not collateral attached to it. But we have had some success. If you have a customer
with credit unions, we have a lot of success. I know we have a lot of credit unions on this webinar today. It's a very unique relationship where if there's a signature loan or a credit card, we can be pretty sure there's probably a car loan and other loans, plus family members who have loans, and they're desiring to have a future relationship with the credit union. So if the overall success rate for across the universe of bankruptcies for unsecured loans, getting them reaffirmed is 3%, it's like 30-40% for credit unions. It is astronomically higher because of that member credit union relationship. And they feel a loyalty, they feel a vested interest in doing so to keep the relationship so they can get future loans from that credit union. And the other part, which we didn't touch on, is there are special rules for credit unions within the reaffirmation process that, there is a hurdle that you do have to overcome as a creditor to get your reaffirmation agreement approved by the court. And that is to prove that it is not imposing an undue hardship on your borrower to have them agree to this. So just because there's a car loan out there and your borrower wants to reaffirm and you're happy to do it, if this is somebody who has very limited financial resources, and yet they made a terrible decision and they bought a $95,000 car, and they just really want to keep that car even though they clearly on paper can't afford it. If you're not a credit union, the judge may very well say, I'm not going to approve this. This is definitely going to impose an undue hardship on the borrower going forward. But if it is a credit union, the undue hardship provision is waived. It is not something that has to be overcome when a credit union and a borrower are entering into a reaffirmation. It is assumed to be a presumption of no undue hardship, and really it could be the most ridiculous loan in the world. It could be a Ferrari with a BMW attached to it, and they owe $200,000 and they make $20,000 a year. The judge cannot disapprove that reaffirmation agreement on undue hardship grounds.
Okay, so we just got another flurry of questions. Actually, looking at all these questions,
coming. That's all right.
We probably could have done reaffirmation as a sole topic, but there is a lien question. So what I'm going to do is I'm going to start with that lien question. You don't have to address it directly, but we'll transition into the lien portion to give enough time so we can address both subjects. And then I'm sitting on all these other questions. If we have time at the end, we'll circle back on the question. So, all right, not reaff related, which is fine because it's going into our next subject.
Okay.
So the question is, but the intended to surrender it. Auto loan originated May of 03, Chapter 7 filed in January of 04. Debtor wants to surrender the vehicle. It turns out the lien was never perfected. What are our best steps? We are unsure as to whether the debtor's attorney is aware of the lien imperfection. So really tough question to start off the second subject, but we don't have to address
23 or 24 or 03 and 04?
It's May of 03 was the lien origination. Bankruptcy was filed in January of 04. So Scott, I don't know if you want to delve right into the tough questions or start with a little lien discussion
I
first.
think we're going to start with the basics.
Okay.
I think this will answer the questions. So
all right,
first of all,
next slide.
Right. Yeah, so let's go to this next slide. Okay. So here's the question. What's the importance of timely perfecting your vehicle lien and the consequences of failure to do so? All right. So in order to answer that question, I think everybody needs to kind of get a little bit of a primer on what are we even talking about? Lien perfection and perfecting your vehicle lien. Every secured debt, the creditor makes a loan and the borrower grants a security interest in collateral, whether it's a home loan and they're granting you a mortgage on the real estate, a car loan and they're granting you a security interest in the vehicle, that's fine. Just saying, like, signing an agreement that says, I'm granting somebody a lien or I'm granting you a security interest in my vehicle, that's a security interest. But and that's creating a lien, but to perfect your lien, you need to go a second level. And that is controlled by the Uniform Commercial Code, Article 9. And as to motor vehicles, the only way to perfect your lien validly is to record that lien on the certificate of title. So filing a UCC statement like you would do, and some of you are familiar with in business loans, and you take a lien, a blanket lien on all the business assets, including accounts and inventory and equipment. That's one thing that you can perfect a lien on those type of assets with a UCC. But to perfect on a motor vehicle, you have one and only one option, and that is to record a lien on the certificate of title. So that's the first thing we need to establish. Now we get into the bankruptcy aspects of it. Can get a little bit interesting. The first rule of thumb that you need to know, there's sort of two time frames here that we have to talk about where you can get in some trouble. The 30-day rule. All right, so from the time that the debtor, the borrower, takes possession of the vehicle, you should record your lien on the title within 30 days from when they take possession. So that's number one. Now, if we're talking about, forget bankruptcy for a minute. If it's no bankruptcy situation, no harm, no foul. I mean, if we're really focusing on, you're going to get into trouble here if a bankruptcy gets filed. But either way, your goal, you need to get it filed within 30 days to validly perfect it. But in a bankruptcy, we have a very special situation, and that is preferences. All right, and the invalidation or avoidance of your lien. So first thing we talked about, you have the 30 days from when the borrower takes possession of the vehicle. And then we get a bankruptcy notice from a borrower and we're like, okay, what's going on here? Now you've got to also look at there's a look back period from the date that the borrower filed, 90 days backwards. And if that lien situation occurred within that 90 days, that's subject to a potential preference claim. So if you have the loan occurring within the 90 days, and you have a situation within that where the borrower took possession of the vehicle and you didn't record your lien within 30 days, the trustee in the bankruptcy has the ability, and in fact, most likely will file what's called a preference action to avoid your lien, to declare your lien to be avoidable. And the end result of that is they will sell your vehicle out from under you. You will be deemed an unsecured creditor. You will be allowed to file a claim in the bankruptcy, but you would be treated as just an unsecured creditor like everybody else, and you lose your lien. So the importance is it's literally life and death as far as your ability to be a secured creditor or not be a secured creditor and still have your collateral when we're talking about bankruptcy. Timely perfecting that lien within the 30 days means now they're in the bankruptcy and we have all the things we just talked about with reaffirmation. If it's a chapter 7, we'll get into some, maybe we'll bleed into a little bit of chapter 13. You'd have the right to file a secured claim. You'd have the right to object to the plan. All these things come into play. But if you don't timely perfect within the 30 days, you run the risk, a very, very likely risk, that you will lose your lien and you will be deemed an unsecured creditor in the case. And that the trustee is given that power to do that. It's called the strong arm powers. And in essence, in bankruptcy, it gives the trustee the ability to stand in the shoes of a hypothetical lien creditor who has a superior lien to you, a bona fide purchaser who has a superior interest to you. All right. So because of that specific power given to the trustee, it can step in and prime your lien and look downward at yours and say, well, your lien is invalid because it was not properly perfected in time. Thus, my lien as a trustee takes precedence over yours. That's in essence what's happening. So it is absolutely vital that you get your lien recorded. Now, all of that being said, I haven't looked to see if we're getting questions, but I know everybody's heads are exploding because they're like, there's only so much you can do as a lender. And this is where it gets really unfair. And I've seen every one of these scenarios, and I know you guys are thinking it, and you've got examples on your desk, or we made a loan and it sat with the title bureau, it sat with the motor vehicle bureau, the dealer didn't get it done in time. That's all well and good, and that doesn't change the fact that the rule is not you mailed it 3 days after the loan was closed and it didn't get recorded till after 30 days and you're still okay. That's not the rule. The rule is it has to be recorded on the title within 30 days. There's no, oh, we almost got it within 30 days, but we had good intentions. You're out of luck. Now, you have recourse as a lender to go back to your dealer and say, hey, you guys didn't properly get it recorded. It's going to be the word of the day, but business decision. This is a business decision for every lender out there to say, how much business are we doing with this dealer? If this is a one-off and we don't particularly like this dealer, well, maybe this is the time when you make the point of exercising your rights under your contract with that dealer, and you guys screwed up. You didn't get the title work done properly. You didn't get it done timely. If you can establish it was the fault lies with them. But if it's simply, no, they did it right too, and they mailed it to the Motor Vehicle Bureau and it didn't get recorded, and it's the state's fault, you're out of luck. Unless Milos feels differently about it. I mean, it's a pretty harsh result.
Yeah,
but that's the reality.
Now, actually, the second question came in after the first, and they kind of tie in together, so it's actually working out perfectly. So the first question, just to kind of circle back, based, to apply what Scott said, loan was issued in May of 2023. Debtor filed a bankruptcy in January of 2024, roughly 6 or 7 months later, and it turns out the lien was never perfected. What are your rights? I really think outside some extraneous circumstances, I think you're out of luck. I think that debtor has a car free and clear, and you have an unsecured loan that was discharged in bankruptcy. I mean,
well,
Scott,
there's no preference. There's not a preference. This is a very different situation.
Yes.
Now what I don't know what the bankruptcy. I don't have enough information to know. Was this a 7? I'm presuming that
it was a 7.
So the borrower filed a 7, and they got a discharge, presumably.
Yes.
So there's no more debt here, and you never got your lien properly perfected. They have a car free and clear. It's how do you go back now and record your lien on a debt that is no longer valid?
Yes, it's the harsh realities of it's a lesson to live by. It's very important that you guys make sure that you do everything in your power to get that lien perfected, because this is going to lead into the second question. And we've had situations with some clients that it wasn't one off. It's been several. So you may want to go back and audit your auto loans and make sure that you guys have a valid lien. And if you haven't, make sure to get that done, because if the member files for bankruptcy, you're out of luck. So the other question that came in that actually I've kind of dealt with on a personally is let's see here. Sorry. Okay, how does it work when vehicles are refinanced and you're waiting on another lien holder to remove their lien before you can place yours? I think I'll tell you from my personal experience. Now, Scott, every jurisdiction is different. Everybody's had different experiences. Even judges within the same jurisdiction are somewhat different how they approach things. So, that's why there's never, when you guys ask questions and it's a general question, it's never one size fits all. It's very fact specific, location specific. But I can tell you, I've had 2 personal experiences with this recently. We've had a client provide financing for the purchase of a lease, and the leaseholder was holding on to the title. They didn't transfer title in a timely fashion, and the member filed for bankruptcy. I think that you're in a little bit better position, because I took the position, we didn't litigate it, but I drafted a brief. I took the position that, the 30-day clock for you to perfect your lien is impossible to be facilitated until the other party complies with their portion of it. So I didn't think that as a lender, you were bound or prohibited from perfecting your lien, because the vehicle, there's a distinction between leases and refinances a little bit. And I think the lease made a little bit of a difference on the fact that the debtor doesn't actually own the car when it's a lease. So it wasn't an asset of the estate. I don't want to get into the complexities of it, but I think you have an argument there to say, you know, we were held hostage by a third party. We were physically unable to perfect our lien. So I think we should be allotted an opportunity to do so after the fact. I think that's a valid argument. But I think that there needs to be more details fleshed out and some more discussion before you simply just do it.
Right.
But I think you're in a better position than simply, you know, we forgot to do it and we let it sit and now it's too late. I think this is a little bit out of your control, so you can put up a little bit more of a fight. But you know, the situation there too is, you know, don't just wait. You know, we've had clients that, oh, we haven't gotten our title from the previous lender. It's been a year. What are you doing? You know, you're relying on the debtor and the member. I think you need to be a little more aggressive and just sitting there waiting over a year to perfect your lien. I think you have to show a little bit more effort if you want to put yourself in a better position if this comes to litigation, simply than.
But I did see a question that came in where they're pointing out a lease buyout or a refinance. It sometimes takes longer than the 30 days, and what do we do? Again, look, there's real world. We can talk esoterically about what the law says, but these guys are on the front lines making loans, and this is what makes the economy go around. Is people are going in to buy cars, and the dealers have so many options of where they can send them for financing. But the reality is, if it goes bad because the person files bankruptcy and the lien didn't get recorded, your recourse, there's no defense to that. There's nothing you can do about it other than you can go back to your dealer. You do have recourse there. That's going to be the ultimate thing. Is just saying it took too long. I get it. It's a harsh result, but it's not like this is going to happen a lot. But when it does happen and it bites you, that may be a very difficult conversation you have to have with your dealer partner, but they got to make good on it. If it was, you know, if it was their, you know, a fault of theirs and not of the title bureau. If it's the title bureau's fault and it was strictly sitting with them, now should they have been following up? There's a lot of facts you can get into to see is it the dealer's fault or not the dealer's fault, but that's the way it goes.
Well, the title bureau, we've had some success with that during COVID, right? Remember, the title bureaus were closed for a period of time during COVID. So
that was a very unique situation. Yes.
But there's some precedent there that if it's, you know, if it's out of your control and the title bureau is at issue and you can prove it, that there you may have you know, some protections there. Well, we're down to our last like 7 minutes. Scott, I don't know if there's any particular questions you wanted to cherry pick on your subject here before we just kind of delve into some maybe I'd go back to reaffs or.
Well, I did want to touch on one aspect of this, which we keep referring to the idea that the trustee's going to, you know, where we referred to the trustee's going to come out and file this preference action. You're going to lose your lien and all. I want to make sure everybody understands how that process, what it would look like, so that if it's happening to you, at a minimum, you understand that it's happening and really you reach out to counsel on that, because it's a good idea to at least see what defenses you might have. You may not have one, chances are you don't, but hey, trustees, they've been wrong before. It will usually come in the form of a complaint, okay? A complaint sounding in 547, section 547, a preferential transfer. That's the kind of thing it's going to be, but it's going to be an adversary complaint that you're likely going to get. But even before that, what you may get is a letter from a trustee, and they're going to use those buzzwords. They're going to explain to you that due to the fact that your lien was not recorded within 90 days or within 30 days, and this transaction occurred within the 90 days preceding the bankruptcy, this constitutes a preferential transfer and is avoidable. If you're hearing the words preferential, avoidable, 547, this is when you need to pick up the phone and reach out to your counsel. All right. Don't wait. Don't ignore it. Don't throw that letter in the mail or in the garbage, and certainly don't throw the complaint in the garbage, because it needs to be answered, responded to. There may be an option. I'm not saying whether it's going to be a defense or it's just a way that we can negotiate something with a trustee. It depends on the situation, where maybe, yeah, you give up your lien, but in essence, you're buying the equity back. where you can basically keep your lien and you own the car, and then you can control it and sell it. And if the math works, it might be a slightly better deal than giving up the lien completely and being an unsecured creditor. At a minimum, what I want you to take from this is, if you get a letter like that from a trustee questioning the lien perfection, or you get a complaint, don't ignore it. That's when you reach out to counsel.
Yes.
So that's what I have to say about that.
We got a few questions after we started discussing this. I think people started getting a little paranoid. Some questions about, what do you do if you can't get the lien or the title from either the refinancing party or if they're purchasing it from a private party. And the question is about, there was another question about do we have to refile a lien if there's a refinance? Those are not bankruptcy related, so those are gonna, we'll defer to another department. So what we're gonna do is, what we typically do is, for the questions that we didn't get to, we're gonna pass those out to the attorneys, and we'll try to email everybody back with a response. So if you guys have any non-bankruptcy related questions, we'll try to get those to the proper party. For the bankruptcy ones, I think we have like 4 minutes, so technically 3, because I have to make some closing remarks at the 1 minute mark. So let me go back and see if there's something we haven't covered. Can we as a credit union charge the members and file it ourselves to avoid any issues? I'm assuming you're talking about a reaffirmation agreement. Well, as always, you're allowed to represent yourselves. You guys can prepare the reaffirmation agreement. Can you charge the credit or the members for the work? Well, that's been coming up a lot lately. I just researched that issue for another client here in Ohio for a mortgage reaffirmation agreement. Can we charge that to the debtor? Yes, but they have to agree. It has to be disclosed in the reaffirmation agreement. My thoughts on that is, why would somebody pay you a premium to just reaffirm a loan they wanted to keep? I think you're doing yourself a disservice, and I think a member would be less inclined if they have to cover a couple $100 in legal fees just to keep a car that they were current on their whole, the whole duration of the loan. And I kind of feel like it's the cost of doing business, and they filed a bankruptcy, and it's just one of those things you have to incur. I mean, you can always, approach the debtor with the subject and ask them if they're willing to pay it, but it's got to be disclosed. They have to agree to it, and it's got to be on the reaffirmation agreement. All right, I got 2 of these questions, so this one's somewhat important. It may be our last one time-wise, but if no reaffirmation agreement, bankruptcy is discharged, but the member wants to keep paying, can they sign a voluntary repayment agreement to allow us to contact them? Slippery slope. Scott may have a different approach on this. I don't know. This is where it gets a little tricky because it's a gray area, but voluntary payment agreement means nothing. It gives you no powers. It doesn't protect you from a stay violation. I think you're wasting your time. The only time I usually recommend those is where you have a situation where a member is either not reaffirmed yet or is not reaffirmed at all, and they were doing an auto deduction from their bank account. The automatic stay, I don't want to dwell on the automatic stay, but when somebody files an automatic stay, you have to stop all the voluntary auto deductions as well, because they're no longer voluntary if they're automated. But if a member comes to you and says, I want to continue paying, I want to reestablish my voluntary payments to come directly from my account, I don't have an issue with somebody doing that, but I would get something in writing. Can you get writing that allows you to contact them directly, try to collect on the debt, send billing statements? I mean, you can do anything, but I think when push comes to shove, I think you're running afoul of the law. If they come back later and say, you're trying to collect on the debt, I think most judges are going to say, you're a lender, you're familiar with the process, you should have known better. You can't circumvent the law and send out the billing statements. If they don't reaffirm, I think you're just at the mercy of the voluntary payments.
I would agree.
Yep. What do we got? We're down a minute, so I'm gonna close it out. I'll do the closing remarks, and then, like I said, you guys can always reach out to us directly. We'll try to go through all the questions that were not answered and either respond, or if they're non-bankruptcy related, we'll try to get it to the correct department. But I'd just like to say thank you for attending today's Weltman webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on a variety of topics such as collateral recovery, real estate, and bankruptcy, to name a few. We'll send you a link to the library in our follow-up email. Thank you again for attending, and have a great rest of your day. One more thing to add, we do drive these presentations on what you need. So, we have had some in the past where it's strictly based on questions you provided. We've had some that have gone based on an overwhelming response that we've gotten from attendees. So, please be aware that your voice does matter, and it dictates what we present and the knowledge that we present to you. So please feel free to reach out and let us know what things you'd like to see in the future. All right.
Thank you guys very much.
Yep.
We appreciate
Thank you.
it.
Yep. Take care.